Good afternoon, everyone. Thanks for joining us for today's session. Today's session is on managing redundancies. It's an overview of the redundancy process and how to get it right. For everyone, my name's Julian Hackenberg. I'm the head of HR advisory at MyHR Australia. We run these sessions pretty regularly on a range of topics. And we thought, given the current economic climate and the sort of queries that we're receiving from our clients at the moment, that it would be, topical to do a session on managing redundancies. Recently, ARI, the Australian Human Resources Institute quarterly Australian Work Outlook report for September 2024 found that about a quarter of employers within Australia were planning on making redundancies this quarter, and then that's up from previous quarters that they've polled people. So at MyHR Australia, we've seen requests for advice relating to redundancies from our clients who are primarily small and medium-sized businesses. We've seen this sort of advice increase significantly throughout the year, and certainly the number of instances for advice have pretty much doubled from this time last year. So, we should say up front that redundancies are unfortunate, but a necessary part of the business cycle for a variety of reasons. But redundancies need to be managed correctly to minimise legal risk and ensure that your business is stronger moving forward. While a relatively simple process, we do see businesses get it wrong, and we regularly receive requests for advice in relation to redundancy matters. Today's webinar is a comprehensive view of redundancy process in Australia. We'll explain the critical steps for every organisation that needs to be taken when laying off staff, focusing on strategic planning, legal compliance, and consultation. So that's today's agenda. Basically, we plan on running for about 20 to 30 minutes or so in terms of running through the topics and then opening up for a Q&A. And so what we'll be covering today is, what is a genuine redundancy, looking at consultation, legal risks, redundancy entitlements, how to support affected employees, and an overview of the process. Before we get into that, I've just got a little bit here on MyHR. So MyHR was established in 2013. We see ourselves very much as the HR department for businesses who don't have one. So we're really a service that provides a platform, effectively an HRIS system, that's run by HR people in the background. So we support 1,400 employers across Australia, New Zealand, and Canada. And we have a range of businesses from, really not many staff at all to, some reasonably large employers. We see ourselves as a cost-effective solution, given that we, provide the platform and advisory services, and there's no lock-in contracts attached to that as well. Now, before we begin, just a bit of housekeeping. Today's session is being recorded. Recordings will be available afterwards on our website. So any questions will also be recorded and will be available afterwards. So just say that only share information with us that you're comfortable sharing with the broader public. So really just trying to keep names and that sort of thing confidential. Slides will also be available after the session as well. But certainly we just want to reinforce the point that questions are most certainly welcome. So I guess today, looking at the context around what we're talking about today, and I suppose, as I mentioned earlier, we're seeing a lot of queries coming through from our clients who are basically saying that they're doing it tough and are looking to restructure their businesses or their business or cut costs or just sort of review how things have been run in the past. And so, just sort of looking at the economic climate, in a situation of sort of low business and consumer confidence at the moment. Certainly, I think businesses are looking at increased labour costs. So, we've seen over the last couple of years some of the biggest minimum wage increases, trying to keep up with inflation. Certainly increased regulation, and we've seen some further regulation introduced earlier this week through the sort of right to disconnect and some changes to casual employment as well. There's still some skill shortages out in the labour force, and certainly sort of low unemployment rates have meant that recruiting staff is difficult, and you sort of have to pay up to bring staff in. In addition to that, sort of economic turbulence, post-COVID, higher interest rates, a bit of a cost of living crisis. At the same time, we're seeing the sort of costs of outsourcing and offshoring are really coming down. And so, we're seeing a lot of that from our clients around, they're sort of losing contracts or losing clients. They're also just sort of seeing benefits of potentially looking to other sort of labour markets as well. As I mentioned, that RE report, about a quarter of employers are expected to make workers redundant over the next quarter. That they've also sort of mentioned it in terms of that, like the redundancy intentions are high, but recruitment intentions are also high. So it seems to me that there is a bit of a sort of restructuring, rearrangement of the labour force. Sort of reorganization. Reflecting sort of changes composition of the workforce and changing sort of skill requirements. Looking at things like digitalization, automation, AI, etc. So I guess it's not necessarily a bad economic times leading to cutting jobs. It's a bit more sort of nuanced than that, but certainly there is that component in terms of the context around it. So just before we begin, just a bit of a vibe check. We, at MyHR, as I said, we really aim to partner with our clients. We try not to take a one-size-fits-all approach. Effectively, we see ourselves as an HR business partner to our clients. And so therefore, we advise of risks, obligations, and options. We feel like we're really pragmatic when it comes to dealing with matters, including matters such as redundancies. But at the same time, there are risks for getting these kinds of things wrong and these processes wrong. So that's just, we're not lawyers. So we're not there to tell businesses purely what their legal obligations and legal risks are. We try to place our advice within a broader perspective, looking at, the legal risks, but also looking at the sort of broader organizational risks and looking at the broader organizational context as well. So that's just a bit of sort of information on our approach around how we go about advising clients when it comes to employment relations matters, including redundancies. Now, I've got a bit of a poll before we sort of get started as well, and I might just launch that now. So hopefully everyone can see that. It's just really, who has recently made a role redundant or is planning on making a role or roles redundant within their business. A few people are responding, so that's good. Seeing a few responses coming through. It's sort of, for the most part, it seems, I might just end the poll there, but 65, 67% responding yes. I guess that's why you're attending a session like this. We don't aim to run these sessions for HR people. We really aim to run these sessions for business people, and so it's good that we've got 2/3 of the audience who are here for some genuine information that they think will benefit them. All right, so always wanting to set the scene, look at the foundations when it comes to employment law and employment relations. Basically, this sort of stuff we need to have in mind when undertaking these kinds of processes, of course. First things first, the Fair Work Act is the piece of legislation that governs employment within Australia. And within that, it really sets out the national employment standards, which has a range of minimum entitlements attached to it, such as maximum hours of work, annual leave, personal leave, other leave entitlements. In addition to that, it sets out redundancy entitlements, minimum entitlements around notice for termination, etc. On top of that, or within the legislation, the Fair Work Act, you've got a range of employee protections. So you've got unfair dismissal protections. So In terms of how that relates to redundancy, basically a termination won't be an unfair dismissal if it's a genuine redundancy. So there are processes or mechanisms in place for employees to bring unfair dismissal claims. They can do so for any instance when once they qualify. So basically there's a qualifying period for employees to have protections from unfair dismissal. It's either 12 months or 6 months, depending on the size of the business. Once they qualify, if they are terminated, they can bring an unfair dismissal claim. And therefore, when it comes to matters of redundancy, a business would need to demonstrate that a redundancy is a genuine redundancy, and therefore avoid having to follow that process of resolving the unfair dismissal claim. But we'll go through that in a bit more detail as well. But that's certainly the main risks to be aware of is that unfair dismissal risk. It can be time consuming to deal with those. There is significant compensation that may need to be paid to the employee. Currently the cap is $87,500. That is the maximum cap that employees can receive through an unfair dismissal claim. There are other protections to be aware of, general protections. So that's basically employees are protected from having action taken against or adverse action being taken against them for exercising a workplace right or utilizing a workplace entitlement. So we just need to be aware of these risks as we're undertaking redundancy processes. So, if we're sort of making one role redundant amongst a whole range of roles, and that employee has recently exercised a workplace right or utilized a workplace entitlement, then, unless we've got a really good reason to say why that role is redundant and the other ones aren't, then that exposes us to some risks that are right there. And then employees are protected from discrimination because of their race, color, sex, sexual orientation, and so on and so forth. On top of the Fair Work Act, there is the modern award system. So most employers would be aware of modern awards, but basically they provide minimum sets of entitlements to employees within an industry or an occupation. Entitlements include overtime pay, penalty rates, leave loading, and so on and so forth. Important to this discussion is awards also provide specific obligations on employers to consult with employees when it comes to major workplace changes, including changes that may result in employees being made redundant. Awards also have entitlements around job search entitlements whilst in their redundancy notice period, and also employees leaving during a redundancy period and maintaining their redundancy pay. Then on top of that, you're seeing the triangle there, employment contracts and policies. So, employers and employees can negotiate specific individual terms that apply to the employee or the particular enterprise. So a business might have a specific policy around managing redundancy processes. An employment contract might have a specific notice period that applies to the employee. So those things obviously also need to be factored in when it comes to these kinds of processes. So it begs the question, what is a genuine redundancy? So effectively, the simple, straightforward definition is a genuine redundancy is where a business no longer requires a role to be performed due to changes in the operational requirements of the business. They comply with any requirement from a modern award or enterprise agreement to consult with the affected employee, and there is no reasonable opportunity to redeploy the employee into the business or associated entity. So there are three effective things there. One is the role isn't required. Two is that they've consulted with the employee if there's a requirement to. And three is there's no opportunity for redeployment within the business or within an associated entity of the business. So a dismissal is not a case of genuine redundancy if it would have been reasonable to redeploy the employee, as an example, or if the business has failed to consult with the employee, as an example, even if there is genuinely no requirement for the employee's role going forward. So we get this question a lot around a job or a role, what if there's components of the job that need to still be done and we want to give that to somebody else to do? That's fine. Basically, a job involves a collection of functions, duties, or responsibilities. So some of those duties may be redistributed to another person, but the entirety of those duties can't be redistributed to another person. So it might be a component, it might be like a third of a role, something will be distributed amongst their team members or to another particular role. But that would be fine, because we're effectively saying the role as it's required, including that portion of the job, is no longer required, and we've got a sort of backup or another capacity for other roles to perform, other positions to perform those duties. So in terms of operational requirements, that could be any number of things. It could be, a downturn, as we sort of mentioned. It could be, restructuring a business, around redistributing duties across different parts of the organization. It could be the closure of a site or a store or something like that. It could be outsourcing those positions there, outsourcing those duties to someone else. We've seen examples in the past of employees, being replaced, they're being made redundant and they're being replaced by somebody else shortly after. We've seen instances of in redundant employees' entirety of their role being redistributed to somebody else. Those instances wouldn't constitute a genuine redundancy, because they are required to, they require to be performed by someone. It's just not that particular individual who was in the role. So, that causes an issue in and of itself. So we move on to consultation. And I'd say this is probably where most matters and unfair dismissal matters, employers get caught out. So most, if not all, modern awards have a provision within them to consult with employees about major workplace change. So there's sort of standard wording. I'll sort of copied and paste on the screen there. So basically, where a business has decided that it wants to introduce major changes in production, programming, organization structure, or technology, it's likely to impact or significantly affect employees. They also require the employer to notify any employees who might be affected by the proposed change and their representatives. Discuss the proposed change with affected employees and any representatives as soon as possible after a decision is made. Provide them with written information about the changes, how they might be affected, and any measures the employer will put in place to prevent or reduce any adverse effects, and give prompt consideration to any matters raised by the employees and their representatives. While an employer must consider the matters raised by employees, they don't have to obtain consent of the employees or the representatives to make the proposed changes. And so we do often get questions from our clients when it comes to this consultation phase. It's like, what is it? What do we have to talk about? We've already made this decision, or we're already progressing towards this decision. What are the employees going to say that's going to change anything? I guess in short, they're probably not going to say a huge amount that's going to change anything. However, the law effectively requires, where an employee is covered by a modern award or enterprise agreement, that employers consult with employees about these changes. And if you fail to do so, then any redundancy may not be considered a genuine redundancy, even if the role isn't otherwise required. So I suppose the main things that I would think need to be discussed with employees when it comes to this consultation. Actually, I should point out before I get to that, is the requirement is to notify or to consult with employees once an employer has decided to introduce major changes. So really, I guess once that decision is made, or the consideration around the decision is made, that's really when affected employees should be notified and be involved in a level of consultation. So I guess the main things are that I would think must be spoken about is like, what is happening? What's the change that's being implemented? Why is it happening? How does that change impact on the employee? What other options has the business considered? What support the employer will be able to provide to the employee during the consultation or during the notice period, EAP services or assistance to do up their resume or job seeking assistance, and of course whether there are any redeployment opportunities as well. In addition to that, you're looking to sort of just discuss logistical matters, really. So if we do go down this route, this is what it looks like in terms of a potential end date, redundancy entitlement, arrangements around notice periods, and the like as well. This is the process around determining who would be redeployed into remaining roles within the business. It's really sort of that level of transparency around, this is the situation. This is the decision that the business is looking to make, and these are the reasons why and how it impacts you. And then, we haven't made a final decision yet. We want to engage you. We want you to provide input for us to consider before we make that final decision. And again, as that point down the bottom there says, while an employer must consider the matters raised by the employees, they don't need to obtain consent from the employee's representatives to make proposed changes. Often, particularly for SMEs particularly for SMEs whose business structures are a bit simpler, the information put forward by employees, often employees will say, well, I can see there is a genuine reason to make these roles redundant, and so therefore I've got nothing to contribute. They might have a few questions, but it's really given them the opportunity to put something forward, and that's where that's really where the value comes from. Well, the requirements come from there is the opportunity to put something forward for consideration. However, it doesn't necessarily need to influence your decision making. Of course, some feedback from the Fair Work Commission in some cases that I was reading. Consultation should be meaningful and should be engaged in before a decision is made to terminate. It's not a perfunctory task. A consultation is providing the individual or other relevant persons with a bona fide opportunity to influence the decision maker. So it's really about providing that genuine opportunity to put matters forward for you to consider before making that decision. In terms of information put forward, it doesn't require employer to disclose any confidential information that might be contrary to their interests. However, ultimately, you really need to be upfront with the employee and make them aware of what's occurring, why it's occurring, and all that sort of information. As mentioned, there've been a couple of cases where businesses have been caught out for not consulting with employees being made redundant. There's one case I was reading earlier. The Fair Work Commission found that an employer made the decision to change company structure, knowing that it would likely result in roles being made redundant months before employees were notified that their role was redundant. And they've stated that consultation is not merely telling an employee that they've been made redundant several months after a decision has been made to restructure their team. In that case, there's evidence that a decision was made, say in June, to restructure a team, and that roles will be made redundant, but then employees were only notified that they'll be made redundant in November, and then consultation occurred at that time. Employees weren't given the opportunity at that initial date to actually contribute and be engaged in that conversation and put forward things for the business to consider. They were really only engaged at the business end when they were being advised that they were being made redundant. And so the view from the commission was that's not genuine consultation. Okay, redeployment, that's another area where some employers do get unstuck as well. So what is reasonable redeployment? So whether a redeployment option is reasonable will depend on a range of circumstances, including whether there exists a job or a position or other work which the employee can be redeployed, the nature of any available position, the qualifications required to perform the job, the employee's skills, qualifications, and experience, and the location of the job in relation to the employee's residence and the remuneration which is offered. Employees must also consider redeployment options within associated entities. So you recall earlier around what's a genuine Redundancy is sort of three parts: is the job's no longer required, the business consults with employees where it's required to do so, and there's no redeployment options for an employee. So if you're making a particular role redundant within one part of a business, but there is another part of the business that has a role vacant or available that this employee could reasonably perform, it makes sense that there's an obligation or some part of the process whereby that employee is redirected or redeployed into that open role, so that their employment is maintained as much as reasonably can be expected. It doesn't require that the business create another role for the person. There needs to be another role that exists. The job must be suitable to the employee, so they must have the skill or competency. It must be within a reasonable location, or sort of be around their sort of benchmark around remuneration. So if all those things aren't aligned with what they're, if they're performing, a job as an accountant, but you've got jobs available in sort of an IT setting, that's not necessarily going to be a great fit in terms of roles that the employee should be redeployed, should be considered for redeployment. However, lower income and less responsibility should be considered. So if someone in a manager role, that role's being made redundant, they've been advised of that, and there are more junior roles available within the business that person could reasonably do, then that employee should be offered those roles as reasonable redeployment. Now, they may decline that offer, but in order to meet your obligation, you should definitely offer those roles to the employee. And it's not the case that they should have to go through like a selection process, like the job's advertised, they have to apply and then go through an interview process or anything like that. Really, if there's a suitable role for them to be redeployed into, then they should be redeployed into that role. And so there is sort of a couple of cases where, again, that I was reading, whereby an employer was making a role redundant. The employee was not offered a lower level role with a lower salary because the employer didn't want to insult the employee, so to speak, and so they never offered it to them. The employee made an unfair dismissal claim. Fair Work Commission found that they should have been offered that redeployment, and so therefore the employee had success with that claim. Likewise, there's been some cases where employees being made redundant of vacant roles in other countries, so other jurisdictions, and so there's that consideration around redeployment options within associated entities. That includes associated entities overseas. Okay, on to redundancy entitlements. So this is important to know, of course, because in Australia there are entitlements that need to be paid to employees who are made redundant in some circumstances. It's different to other countries where there isn't necessarily an entitlement. So I know, for example, within New Zealand, that's not the case. And so we deal with a lot of New Zealand employers expanding to Australia, and sometimes they're shocked to hear some employment entitlements in Australia, but and this is one of them. So National Employment Standards provides entitlements to employees being made redundant. So redundancy pay based on length of service. So after 1 year's service, it starts at 4 weeks, and it kicks up to 16 weeks after 9 years. Then it goes down to 12 after 10 years, because it factors in that employees will receive long service leave pay after that sort of 10-year mark, typically. So small business employers are excluded from paying redundancy. So a small business employer is one that employs less than 15 employees, and that includes regular and systematic casual employees as well. Redundancy pay is calculated at the employee's base rate of pay for their ordinary hours of work, but it doesn't include additional payments such as loadings, allowances, overtime, penalty rates, and so on and so forth. Importantly, some awards have industry-specific redundancy schemes, and I'm thinking here something like the Building Construction General on Site Award, and basically that trumps the National Employment Standards, and so that award has a specific entitlement that needs to be paid to employees that applies instead of the national employment standards. So, of course, in addition to redundancy, employees need to be paid their accrued entitlements, such as annual leave, long service leave, where applicable, and also notice as well. So sometimes I speak to employers and they get confused around, they think the redundancy payment is also the notice payment as well. They're two separate payments. So if an employee is made redundant, they need to be provided with notice. They also need to be paid the redundancy amount as well. In terms of the notice, it's like any instance of termination, an employee could be paid in lieu of working the notice, or they could work out the notice. Typically for redundancies, an employee would be paid in lieu, because it's one of those instances where it's probably in everyone's interest that the employee's exited from the business as soon as possible, but not in all cases. Sometimes employers and employees are happy for the employee to work out the notice period. Yeah, and then modern awards, as I mentioned earlier, may provide other entitlements or requirements there around giving the employee time off during their notice period as well. So if the employee's been allowed, basically provided time off to apply for jobs. Okay, cool. So a bit of an overview of the redundancy process. So effectively, the first stage really is planning in a business case. And this really is essential because you really need to demonstrate that, one, the job isn't required. You really need to have a business case around what the process is going to look like. You need to, factor in reasonable redeployment, as mentioned. It's sort of factoring all this stuff in terms of the entirety of the process. I do have a question that's come up, so I think I might just jump into that because I do like having questions come through. So if you are an international company but only employ 10 people in Australia, do you qualify as a small business and therefore are not required to pay redundancy? This is one of those questions that comes up a lot. And our view is that you are, so in that case, if you've got greater than 15 employees across the globe and only 10 in Australia, then you're still considered a large employer for the purposes of the Fair Work Act. So you're not excluded by way of being a small business employer in that instance. So even though you've only got 10 in Australia, in totality, you got, say, 20 across the globe, then you're no longer considered a small business employer in that case. But that's one we get quite often. And someone's just asked for the recording at the end via email. Yeah, so that will be sent out at the end of the webinar as well. So business case planning, really want to be across and having a sound reasoning behind the decision, and then really sort of planning out what the process will look like with your employees. The next step is notifying the affected employees. So they should be notified in writing that their role is at risk of being made redundant and provide them with all the relevant information, including the nature of the change, i.e. what's happening. Is there loss of a contract? Is there a relocation? Is there a business sale? The expected effect on the employee. So is it expected that they're going to lose their role as a result of this? And any other matters that will likely affect the employee. So outlining the consultation process, i.e. we'll meet with you to consult with you about this on X date. Any redeployment options that we think might exist. Also outlining just sort of redundancy entitlements, whether we've got an EAP or outplacement services as well. So we want to sort of set that all out to the employee up front. So they've got all of that information in front of them. They can consider that in terms of responding throughout the process. As I mentioned earlier, you don't need to disclose anything that's, confidential in terms of like financial statements or anything like that. It really just needs to be, hey, these are the circumstances that we're confronting at the moment, and this is what we're going to be doing about it. And because we're doing something about it, it impacts on your role. Typically, you want to give the employees sort of 24 to 48 hours notice of that meeting occurring. Consultation meeting, so that's the next step. So you're meeting with the employee or employees about the matter at hand. So, discussing proposed changes, outlining sort of, I guess you're handing it over to the employee at this point to ask any questions. for you to respond to those. And sometimes employers will have like a pack available to the employee. So when they notify them of the change, they'll have, like an FAQs, or maybe not FAQs, but they'll have like a list of anticipated questions that the employee might have. So they're providing all that sort of information to the employee in advance. But then the consultation meeting is really about that, to expand on that. So they might have a whole bunch of questions around the change, why it's impacting them, why the business is making this decision. Has the business thought about doing something else? Or maybe they might put forward that they're happy to work part-time rather than full-time hours or something like that. There might be a whole bunch of suggestions that employer might make. As mentioned earlier, it doesn't necessarily need to influence the ultimate decision, but you need to demonstrate that you considered it. And so holding a meeting, having all this in writing, responding to the employee perhaps after the meeting with follow-up responses is all really handy stuff to have to demonstrate that you've genuinely consulted with the employee. You're also discussing with them, around entitlements, whether or not you want them to work out the notice period, what the sort of next steps are likely to be in terms of notifying them of the outcome. Again, reinforcing that, if EAP is available, and that sort of thing. As mentioned, it doesn't necessarily need to influence the outcome, but you should definitely consider the suggestions that the employee put forward. Those Fair Work cases, Fair Work Commission cases mentioned before, really, suggests that consultation should be genuine. So we genuinely want to consider their responses. Formalize any redeployment options after that as well. So if, as part of that consultation, the employee has expressed interest in redeployment into another role within the business, then you can provide them the specific offer after that point. And then assuming that, employees are to be made redundant, then really just advising them of the outcome post that. So it doesn't need to, it's not really that convoluted a process. It's really notify, consult, and then notify of the outcome being the redundancy. So provide the employee with a letter confirming the details, again, payment in lieu of notice, work in the notice, redundancy entitlements, access to EAP, job search entitlements, and that sort of thing. So I suppose just my sort of lessons learned around running a few of these processes myself. And sort of most things HR, you can advise and advise and advise, but it's until you're sort of running these things yourself that you actually properly learn about these things and how they impact people and that sort of thing. I'd say you can't over communicate with employees in this position. It does come as a shock, certainly, almost in every case. And so really just being there for the person, conveying to them what's occurring and why it's occurring, being upfront, being available to them to ask questions. Like, there's a formalized process, but I think in an ideal situation, there's lots of conversations occurring throughout. So I think my big thing is you really can't over communicate when it comes to something like this. Because secondly, have the organization at the center of your decision to make a role redundant or restructure. Sustainable organizations are important. It's important that we're making decisions in the best interest of the company, but have the person or the people at the center of your process. So when it comes to that redundancy process, you really want to have the people at the center. You really want to be flexible. You really want to, be available to them and be really, when it comes to that consultation meeting, be really open, be really honest, be really upfront, really give them the opportunity to put their views forward for you to consider and really demonstrate that. And get your ducks in a row. Have a plan, be confident, avoid confusion on the part of the employees leaving and the employees remaining as well. So you really want to plan it out. You really want to be across, all right, what are we doing? How are we communicating this to employees? What are we providing the employees in terms of information? What are we doing with employees around, notice periods? How are we communicating this to the employees who are remaining within the organization? You really want to have planned out all those things. So you're not just sort of winging it and just sort of leaving yourself open to sort of looking silly or being unsure or putting sort of doubt in the mind of employees who are leaving, or even more importantly, in some ways, the employees who are staying. All right, just a few notes on survivor management. It's really important to consider the employees who are affected and who are being made redundant, of course. We've sort of gone through great detail around that, but also the employees remaining. So again, it's really important to communicate openly and proactively with the employees who are remaining. We really want to, just be upfront and sort of name the ugly, acknowledge it, acknowledge what the business is going through. Offer support to those guys as well. I think it's important if they've worked with colleagues, made friendships, that we acknowledge that they might have some concerns around losing those people. They might have some concerns around, relationships and the business itself as well. So they may wish to speak to people. Again, some supports internally as well. Certainly team building, coaching. Maybe you want to be a bit more regular with check-ins and that sort of thing throughout these periods. Get feedback mechanisms in place. Address uncertainties where possible. Maybe having a town hall, people can raise questions, and that sort of thing. But you really want to sort of refocus the business and really highlight the direction that we're heading while we're making these decisions, and sort of getting everyone on board for that sort of next phase of the business. I guess just closing out, we've got a few frequently asked questions that we often get when it comes to this sort of thing. What is reasonable redeployment? We sort of touched on that earlier. Really, you're looking at any role within the business that the employee could reasonably perform, including if it's not necessarily within their current work location, even if it's a lower rate of pay, even if it's got junior responsibilities. Effectively, you're looking at any role that might be able to maintain their employment. Doesn't need to be a role that's created specifically for them. It's really if the role's vacant that they're able to perform, then really they should be offered that redeployment opportunity. We often get questions from clients around when can they re-employ in a redundant role. So they make a role redundant and say a few months' time, they, for whatever reason, they want to re-employ someone in that role. That creates a bit of a risk. An employee can make an unfair dismissal claim around that down the track if they think that they've been made redundant, but just to get rid of them, just for the business to re-employ somebody else. There's no hard and fast rules around this sort of thing, but you certainly want to be able to demonstrate there's significant changes, that have meant that you need to re-employ somebody, a few months after you've made the role redundant. So has there been an upturn in, the economy, or you've got new contracts, or something has changed that means you need to bring that person back on, or bring that role back on. Does casual service count towards redundancy pay? It does not. Casual employees receive a casual loading that compensates them for not receiving entitlements under the National Employment Standard, including notice of termination and redundancy pay, amongst other things. Therefore, provided that they're a genuine casual and they had that casual loading identified within their pay, then there should be no reason to factor that service in when paying redundancy pay if they're made redundant down the track after being in a permanent role with the business. Small business employer, we touched on this as well. Less than 15 employees, anything above that, including within associated entities and overseas associated entities, is considered a large or a non-small business employer. That also includes casual employees who work on a regular and systematic basis. And what is consultation? So consultation, as we've identified, is a specific obligation that employers have when making roles redundant, where the employee is covered by a modern award or enterprise agreement. And so employers are required to consult with employees around major workplace changes, notify them of the change, give them the opportunity to put their views forward, consider their views before making the final decision to make a role redundant. Okay, so that wraps up the webinar. Thanks for everyone for attending. We have an opportunity for people to ask questions. If anyone does wish to ask questions, now is the time. I know we've covered a lot. It is a bit of a big and beefy topic, but we've had a few questions throughout the session as well, but I might just leave it open for a couple more moments for any questions that might be out there. Anyone? No, not seeing any come through. So look, thanks again for everyone attending. Yeah, I think it's been a good session. Hopefully everyone got something out of it. If you would like more information about this or other, oh, someone has asked a question. Okay, cool. Just as an example, if we made made redundant a senior role, and 2 months later we're hiring another role, and we did not offer the redundant employee that role as we did not know we would require it later. I understand we could be subject to unfair dismissal, correct? Potentially, yeah, potentially. I guess it would come down to, yeah, whether or not that role was vacant and available at that time, or you would foresee that it was going to be vacant and available to redeploy the employee into. So, you know, I think if it's only a couple months later, then you really want to be quite clear as to what's changed that meant at that time that you're making the senior role redundant. Why you couldn't foresee that there'd be a requirement for this more junior role, and therefore didn't consider that person for the junior role. It really comes down to the circumstances at the time, because things might change. Two months is a short period of time, but it's, you know, a lot can change in 2 months at the same time. So it depends really on the circumstances. Okay, if you have excess staff in a certain area due to reduced workload, is redundancy the right path to take to reduce the numbers? Yeah, it could be. Yeah, it could be. I mean, you'd need to look at the specific circumstances, but that is one of the cases where a redundancy process might be suitable, is that you've got too many employees for the level of work required, and so therefore, you know, you've got 5 employees or 5 roles, but only have sufficient workload for 3 roles, and so really, therefore, 2 roles are effectively redundant in that situation. And so in that case, you'd probably be looking at a redundancy process. And in that case where you've got like a reduction in roles, albeit roles remaining, you want to be really clear around of the 2 of the 5 employees who are currently in that org structure, the 2 employees who won't make it to the remaining 3 roles, but what's the reasoning behind those 2 and not everyone else? So you probably want to have like a bit of a criteria, you know, assessed around, you know, their skill set, the history of their performance, all that sort of stuff, that you can demonstrate that there's like a reasonable and fair and lawful process around those employees going into the remaining 3 roles. If a role includes a number of employees, are all employees required to be consulted? It really is only the employees who, well, I guess I would say when it comes to consultation, if you've got a you know, a department or an area of the business that is up for review or is potentially being restructured, then really you're wanting to consult with all of those employees around that. So you're just wanting to sort of engage them as part of that review process. Then you might get down to the point where, well, we've realized that we only really need these roles, and so this role and that role, you know, they're being made redundant because we don't need them going forward. At that point, you're really just consulting with those 2 people. So it's sort of broader consideration. You're consulting, but then when it gets to the termination phase, you're just really consulting with the employees who are directly impacted at that time. Okay, would merging 2 roles as a result of a resignation of an employee be considered reasonable grounds for redundancy if the remaining employee wouldn't be able to perform the combined role? There is an existing employee that performs the dual role, and it is more appropriate to create a second dual role following the resignation. Okay, I just need to think about that one for a second. Would merging 2 roles as a result of resignation be considered reasonable grounds? See if the remaining employee wouldn't be able to... Yeah, I would say so. Yeah. Yep. So basically, you got so you've got 2 roles. One person resigns. You feel like there's an opportunity to merge those roles together, but the person left probably isn't sort of capable, doesn't have the skill set to perform those roles as a dual role. Then yeah, potentially. I mean, we'd need to be really clear on the reasoning why, and be really clear around why they're unable to perform that role. Whether it's based on their qualifications or skill set and so on and so forth. But potentially that would be what you're looking at, because it's really a reorganization of the business structure. But we'd sort of need to work through that in a bit more detail. If you have a part-time position that becomes full-time, can you make the part-time role redundant, or would you have to create another part-time role? If you have a part-time position which becomes full-time, can you make the part-time role redundant, or would you have to create another part-time? Yeah, potentially. Yeah, potentially. So, I mean, I guess the requirements of the role have changed, meaning that there's again a bit of a change to the company structure. The company requirements have changed. Perhaps the employee is unable to fulfill those requirements. Then you could be looking at the potential of their role is effectively made redundant, because there's no longer a requirement for that part-time role. There's a requirement for a full-time role. So yeah, so there's a couple of other questions that have come through that I think that probably a bit more sort of appropriate just to address outside of the webinar. I know we're sort of going at time as well, but I hope everyone has got something out of it. There's people who had a sort of couple of open questions left. I'm happy just to message you directly and talk through those scenarios in a bit more detail. But as mentioned, thanks everyone for attending. I hope you got something out of it. If you'd like some more information on this session or other sessions, you can check out our website. If you'd like more information about MyHR, you can also check us out on the website. And yeah, I hope everyone got something out of today's session. Cheers. Thank you. Bye.